Mr. Dwyer, you may proceed.
Thank you. Ladies and gentlemen, this is about the choices that the defendant made. The choices that he made on August the 1st of 2015 and the choices that he made during his life. And nobody else is responsible. He is. He made these decisions. And you can't blame somebody else for what a grown man decides. Because he has the right to change it. Did he have a bad childhood and a bad mother? Yeah, maybe he did, and he's no different than a lot of kids in this town. Is he depressed? Is he stressed? Well, maybe he is. Most people that live in Memphis are depressed and stressed every time they turn on the news. It doesn't make this okay, and it doesn't mitigate against the choices that he made in his life. And he had every opportunity to change. And he chose not to. He had Mrs. Richardson, who was there for him. A lot of people don't. A lot of kids don't. He had Reverend White, who was there for him. But if you remember Miss Richardson, she told you that when he committed that bank robbery, he was living with somebody else because she had rules in her house, and she couldn't be responsible for that. When he came back from federal prison, he went to live with his sister and then his girlfriend. Not Mrs. Richardson, because she had rules in her house, and he doesn't like the rules. Reverend White told you that when he was a child, Reverend White provided opportunities for young people in the neighborhood when gangs and crime became prevalent. And when he got out of prison, he went back to that same lifestyle, ladies and gentlemen. Dr. Walker, the psychiatrist for the defense, said that he has an aggressive behaviors play a prominent role in his life. He is easily angered and has a hostile temperament, and he is likely to display extreme temperament or violence when he doesn't get his way. And that is what this is all about. It's about him not getting his way. Desrick Ivory lived because Desrick Ivory gave him what he wanted. Sean Bolton died because he wasn't going back to prison. He's filled with hatred for everybody that gets in his way, ladies and gentlemen. He can't stand authority figures. He said that to the people at Alliance Healthcare. His juvenile record reflects that he shoots at things and he threatens people when he doesn't get his way. And his prison record reflects fighting, disobeying the orders, having weapons while he's in custody, gang-related activities. And law enforcement has always stood between that defendant and organized, peaceful society. So, ladies and gentlemen, it's time to call this exactly what it is. Did this happen because he knew that Sean Bolton was a police officer? This happened because he hates police officers. And 6 weeks before he killed Sean Bolton, he posted a picture of people beating a police officer with a caption, "This shit's funny." He hated law enforcement. He hates law enforcement, and he hates everything they stand for. He murdered Sean Bolton, ladies and gentlemen, because he was a police officer. And everything he did that night shows his hatred. He shot Sean Bolton in the face. Shooting somebody in the face is an extreme display of hatred because you're destroying who they are. And then he shot him repeatedly while he was on the ground, holding his face together, helpless. And what should be the punishment, ladies and gentlemen, for somebody who murders because they despise what somebody stands for? What should be the punishment for that? What should be the punishment for hating a particular group of people. Look at it, ladies and gentlemen. Look at the face of somebody that is filled with hatred. Look at the face of a coward.
Mr. Wilbourn, it is in your best interest not to say things and use profanity. Mr. Wilbourn, it's in your best interest not to continue on this dialogue. Mr. Wilbourn, if you want to stay for the rest of the trial, you may, but this outburst will not be continued. You can step in the back then, Mr. Wilbourn. You can step back in the back. We're going to request a question tonight. Discuss the case itself.
Attorneys are allowed to move around the courtroom in criminal court and in the courts of Tennessee. And so that is what was done here. And again, Mr. Kangaroo has acknowledged that there's nothing inappropriate about pointing. Your Honor has already made that ruling. There's nothing inappropriate about pointing. The fact that the defendant cannot control himself during argument is not a fault of the attorneys. That has to do with Mr. Wilbourn and his choices and what he chose to do in that moment. There was no touching of him, no inappropriate comment about him other than what was pertinent to the argument that was being made to the jury. The way the courtroom is set up, your attention is not automatically drawn to the defendant in this courtroom. So what she did was ask them to consider his actions and his choices, and that was part of the argument. Nothing in the state's submit, there was nothing inappropriate about that, and certainly nothing that would give rise to a mistrial in this case.
Ms. Handel, in additional statements or arguments?
Thank you, Judge. To be clear, the comment that was made was again towards the effect that this is the face of hatred that and that comment or whatever was said, paraphrase, but this is a face of hatred, was intended to provoke Mr. Wilbourn, and it did. And understand that lawyers have the right to move around, but with that said, the state was less than 2 feet away from Mr. Wilbourn. And pointing at him, Judge, and his face. Mr. Wilbourn has been surrounded by the DRT team, and again, this comment was absolutely intended to provoke Mr. Wilbourn. And it did.
There was no shouting, Your Honor. This was always long. Ms. Swire's been told that she's difficult to hear as it is. She certainly was not shouting in this instance, as Mr. Hughley indicated earlier. Also, this isn't a very large courtroom, so in order to move anywhere near the defendant, she would have been fairly close. And what was said was, look at the face of someone who was filled with hate, and she had been talking about the hatred displayed to the victim in this case in relationship to the aggravating circumstances that were found in this case.
Your Honor, the state was absolutely shouting.
refused to stand flat out, refused to take the witness stand flat out, said, Judge Coffey, I would do what I want to do. Flat out refused to even stand up while I talked to him. Never had a person in this court in 12 and a half years been a judge, 32 and a half, 33 years been in practice law. Never had a person other than Mr. Wilbourn who would not do what the judge ordered him to do. Mr. Wilbourn told me why I don't have to come up there. Refused to stand, refused to acknowledge, refused to take an oath, and sat in that chair and told me what he wanted to tell me. Jury arguments, there are things that both sides can argue, and the law recognizes that lawyers in criminal cases are expected to be zealous advocates, and they are afforded, and this is language from Tennessee Supreme Court, great latitude in both the style and substance of their arguments. And that's States v. Banks, B-A-N-K, that's 271 Southwest 3rd, page 90, 2008, Tennessee Supreme Court opinion. And prosecutors have a special duty. The case law indicated the prosecutor was not lose sight of their duty to seek justice impartially in their obligation to see to it that a defendant receives a fair trial. Is also from Banks at page 131. The closing argument must be temperate, must be based on the evidence introduced in trial, or must be pertinent to the issues in the case. Again, that's from Banks' case. Banks' case would also indicate the prosecutors, no less than the defense counsel, may use colorful and forceful Supreme Court language, not mine, colorful and forceful language in their closing arguments, as long as it is not straight from the evidence and the reasonable inferences to be drawn from the evidence or make derogatory remarks. There is no way that this court can ever find that the remarks made by Ms. Breyer were designed to provoke the defendant. I have no idea what that means, that it was designed to provoke the defendant. Ms. Wilbourn was sitting there, frankly, looking smug, looking disinterested. As he's told me many times this week, he did not necessarily want to be involved in this. And Ms. Breyer was making a proper argument regarding those things that the state has to prove on this sentence in face of the trial. That this was, in fact, the defendant has been convicted of other felonies involving use of attempted use of violence to a person. That the killing was done to prevent the arrest or aid to escape from Mr. Wilbourn. And that's that the murder was in fact committed against a law enforcement officer. The evidence that's reported during the sentence is that weeks or days before, a short time before his killing, Mr. Wilbourn had posted some very inflammatory, very negative posts on his Facebook regarding police officers, expressing his dislike of police officers, expressing his hatred of police officers, indicating that the police tried to arrest him, they better bring other people because it was going to be a very unpleasant situation if they ever tried to arrest him. And unfortunately, Sean Bolton was riding by himself when he ran into Mr. Wilbourn, ran into someone else. That person took off and ran into Wilbourn with a gun on him that he had no business having. Having made recent press on public social media outlet indicating his hostility to police and how they ever approached it, rather bring more than one because basically they're not going to arrest him. And those are proper arguments that Ms. Breyer was making regarding the aggravating circumstances that the state has to prove in this case. This is not a situation, even in that case, Judge Kraft in the Supreme Court affirmed the argument from the Court Division 8. I'm trying to remember Norma's last name. First degree murder case where prosecuting the case stood at Jackson, thank you. Over the defendant, pointed at the defendant, yelled at the defendant, screamed at the defendant. Supreme Court found that conduct was not, in fact, inappropriate, but what they found was inappropriate was to come and tell us what he did. He invaded the province of Norma Jackson to remain silent. There was no comments made in this court that invoked or intruded into Mr. Wilbourn's election to remain silent. Mr. Wilbourn himself decided he wanted to start testifying, decided he wanted to start yelling, decided he wanted to start telling folks to get away from him, get fingers out of his face, and comments about how he hates everybody. how he hates everybody in here, and how he hates white people, and how he hates black folks who have been controlled by white people. And Mr. Wilbourn showed what is, in fact, his true character, his true colors. Had nothing to do with his prior provoking or inciting Mr. Wilbourn. Mr. Wilbourn has been on edge all week, which is why he has been escorted by DRT, which is why the court took those efforts to make sure that everyone would be safe in this courtroom. Again, he's been escorted. A lot of police officers in this courtroom in uniform. The jury does not know that Mr. Wilbourn is not an escort. He has also stock cuffs on him. The jury does not know that because they're not visible. But that's why the court took the actions that it did, because Mr. Wilbourn, throughout the history of this case, has struck me as somebody who is, in fact, an explosive personality, and that the safety of everybody, not only the lawyers, but even his own lawyers and other spectators. Mr. Wilbourn was a powder keg, and Mr. Wilbourn decided to go. He's been on the edge, been on the verge all week of doing something silly, and when he refuses to follow this court's instruction, take the witness time so I can ask you questions, stand up so I can talk to you, Mr. Wilbourn does what he wants to do. Ms. Dwyer did not incite Mr. Wilbourn, did not provoke Mr. Wilbourn. Ms. Dwyer was making a proper argument that she, in fact, should make in any case. There are 5 generally recognized errors of prosecutorial misconduct that can occur during closing arguments. It is unprofessional conduct of the prosecutor to intentionally mistake the evidence or mislead the jury. That did not happen in this case. It is unprofessional conduct for the prosecutor to express a person's belief or opinion about the truth of any witnesses that may have testified. That did not happen in this case. It is unprofessional conduct for the prosecutor to use arguments to inflame or prejudice the jury. That did not happen in this case. It is unprofessional conduct for the prosecutor to argue something that, in fact, is not the law. That did not happen in this case. It is also unprofessional conduct according to Tennessee cases for prosecutors to intentionally refer to or argue facts outside of the record unless the facts are matters of common public knowledge. And that is State v. Goltz, G-O-L-T-Z, 111 Southwest 3rd, page 1, 2003 Tennessee Supreme Court opinion. That also did not happen in this case. Based on Mr. Wilbourn's actions, he was asking the court to grant a mistrial. And in order for the court to grant a mistrial pursuant to State v. Middlebrooks, M-I-D-D-L-E, B-R-O-O-K-S, 995 Southwest 2nd, page 550, 1999 Tennessee Supreme Court opinion, the court would have to find that something has occurred in the closing argument that, in fact, prejudice the defendant's case that might affect the verdict in this case. The conduct complained of must be viewed in context and in light of the facts and circumstances of the case. The court also has to give curative instructions which I will, in fact, give this jury when they're brought back to the courtroom. The court has to also consider the intent of the prosecutor making any improper statements if improper statements were made. The court has to also consider the cumulative effect of any improper conduct and any other errors on the record. And lastly, the court has to consider the strength and weaknesses of the state's case. And that's pursuant to Judge J.U.D.G.E. versus State 539, Southwest 3rd, Southwest 2nd, page 344, 1976, Court of Criminal Appeals opinion. A mistrial should be granted in a case only if the court concludes that there are no other feasible alternatives in order for a jury to reach a fair verdict on this case. State v. Robinson, R.O.B.I.N.S.O. 146 Southwest 3rd, page 469, 2004 Tennessee Supreme Court opinion. Mandates that a defendant is not entitled to relief. Indeed, it's well established that the defendant would not be permitted to take advantage of his onerous conduct, which he himself committed, and ask the court to grant a mistrial because of his or those things which are the natural consequences of his own misconduct or behavior. And what was saying, who was asking the court to do is to reward Mr. Wilbourn for his outrageous outbursts in this court, for his outrageous language, for his outrageous disrespect of his jury, for his outrageous disrespect of the criminal justice system. He's asking the court to justify to let Mr. Wilbourn act a fool, and I would not clean that up for the record, act a fool and declare a mistrial because he acted inappropriately. And that would tell Mr. Wilbourn and everybody else, if you want to get out of trial, if you want to have a mistrial declared, just do something stupid in court and then tell the judge you got to do this trial because I acted a fool. And I would not reward Mr. Wilbourn for his misconduct, for his outrageous behavior in this courtroom, and declare a mistrial because Mr. Wilbourn chose to act inappropriately in this courtroom. Will deny the request of mistrial because, again, had for the record that the state of Tennessee is not engaged in an improper argument. Again, in the Norma Jackson case, and the Supreme Court looked at simple conduct. Prosecutors stood right at Ms. Jackson, yelled, screamed at Ms. Jackson, raised her voice at Ms. Jackson, pointed at Ms. Jackson. The court did not find any error in that, but they found error in the statement, tell us what you did, why don't you just tell us what you did more. There's nothing in this case that indicated that both or invaded Mr. Wilbourn's right to remain silent, and this is not a situation that the court will, in fact, grant a mistrial in this case. This is not plain error, and if in order for the court to grant plain error, the court would have to find that the record clearly established what occurred in the trial court, that a clear and unequivocal rule of law must have been broken in this case. The court also have to find that a substantial right of the defendant must have been adversely affected, that the defendant did not waive that right or waive the issue for any tactical reasons, and lastly, that the court has to consider whether or not the error, if any, is necessary to do substantial justice. That's State v. Smith, SNITH 24 Southwest 3rd, page 271, 2000 Tennessee Supreme Court opinion. There is no plain error. There is no fundamental error in this case. The argument the state has given was the process given is not an improper argument. It is well within the province of lawyers. As the court had indicated earlier, the defense lawyer in prosecution may make a zealous argument, may zealously advocate their cases, and they may, in fact, make impassioned arguments. Quoted again, prosecutors, no less than defense counsel, may use colorful and forceful language in their closing arguments. And that is what Tennessee law is. And I will not tell a person, not tell a lawyer that he cannot be a devil's advocate, that he cannot use colorful or forceful language. The language that Ms. Wire was using was forceful, but it's 100% within the bounds of what a lawyer may argue. Now, Mr. Wilbourn takes offense to it and starts acting out. That's his decision that he's made, but I will not grant a mistrial because Mr. Wilbourn created error, and I will give everybody else a blueprint. If you want to stop the trial, if you want to continue never to go to trial, every time you go to trial, just do something outrageous, interfere with the administration of justice, and a judge would have to declare a mistrial. You can continue that path for 20, 30, 40 years and never bring a case to a conclusion. I would tell this jury that if they heard enough verbs that they would disregard it. I would tell the jury that if they heard any spectator conduct or misconduct, they would disregard that. I would also tell the jury that any conduct that they have heard or any statements that they have heard or any behavior from Mr. Wilbourn is not a statutory aggravated circumstance. It would not consider that for any purposes, and reaching a verdict would inform the jury again if it reached a verdict based on the law and evidence only. And I will read the jury a charge in the presence of the defendant that he has right to be present throughout every stages of the trial, and that Mr. Wilbourn has made and has chosen voluntarily to be absent for the rest of his trial proceeding. And will allow the state to conclude his argument. We'll read the concluding jury instructions, and will in fact tell the jury to begin to deliberate on this case. To return a verdict that truthfully takes and justice demands, but I would not allow Mr. Wilbourn to control the administration of justice because he chooses to act in court not only as he does apparently elsewhere, but this has been common all week long. Mr. Wilbourn has on many occasions been disrespectful to the court, has refused to comply with court orders, has refused to stand when I asked him to stand, has refused to take the witness stand when I asked him to take the witness stand. And Mr. Wilbourn will finally learn that he's not in charge of the world. And I will not grant him this trial because Mr. Wilbourn's ridiculous, compulsive, repugnant behavior, which is identified with you exhibited in the court today, with no exception to the record of Mr. Daniel. Thank you. On both sides, what you say.
Fancy, Mr. Wilbourn would like to re-enter the courtroom.
Mr. Daniel, he had voluntarily chosen to be absent, and even if Mr. Wilbourn says, I've changed my mind, which from procedure rule 43, the court can involuntarily remove Mr. Wilbourn from the courtroom if the court finds Mr. Wilbourn has engaged, 43B2 has engaged in disruptive conduct. I did warn Mr. Wilbourn about this disruptive conduct. I did warn Mr. Wilbourn that he would in fact be removed from the courtroom. I did warn Mr. Wilbourn that if he persisted in that behavior, that he will in fact be removed. And not only has he voluntarily told me that he did not want to be here, but in fact, and also that he's engaged in disruptive and hostile and aggressive and conduct. And even if he had not voluntarily asked to be absent from the courtroom, I was going to involuntarily remove Mr. Wilbourn. He has waived his right to be present in this courtroom this game. I would not bring Mr. Wilbourn in and take a chance that he would stand up and start yelling and screaming and cursing again and telling folks, and I don't know if you ever heard how he hates white people and how black folks are being controlled by white people and how he hates everybody. That is behavior that I would not tolerate. And Mr. Wilbourn, even if he's not voluntarily removed himself before he's going to involuntarily remove Mr. Wilbourn because of this disruptive behavior, he will not be back in this courtroom for the remainder of this trial because of this outburst and scandal. Are both sides ready to proceed? Yes, sir. Bring up jury, please, take this way. Yes, sir.
Ladies and gentlemen, thank you everyone for saying that. Ladies and gentlemen, let me give you some what's called curative instructions for the outbursts that you might have heard. I can't comment on what you might have heard or what was said or what you thought you might have said because I can't comment on the facts. But you know that Mr. Wilbourn is no longer present in the courtroom, and that's the decision that he's made. The law requires in a criminal prosecution that the defendant has a fundamental right to be present at every stage of his trial. Mr. Wilbourn has chosen voluntarily to be absent from the courtroom during the portions of his trial. That he no longer wants to be present during his proceedings. He has intelligently, knowingly, voluntarily, and personally chosen to waive his rights to be present. And I will instruct you, ladies and gentlemen, that you cannot have any sympathy or prejudice for or against the defendant or for or against the state of Tennessee because Mr. Wilbourn has waived his right to be present in the courtroom during the entirety of these trial proceedings. If you heard statements from Mr. Wilbourn, if you heard anything that he might have said, I want to order that you disregard anything that you might have heard Mr. Wilbourn say. He has the right to remain silent. He's chosen the right to chosen not to testify at trial or sentencing. And if you heard any statements that he might have said before he was removed from the courtroom, I want to order that you disregard that. You cannot consider that for any purpose at all. It is not a statutory aggravating circumstance. And if you heard anything or observed anything about his conduct, I want to order that you put that out of your mind. Do not allow it to factor into your verdicts in this case. If you heard anything else in the hallway, and I don't know whether or not you did, because that accidentally was removed from the courtroom, but if you heard an outburst from any spectators or heard anything in the hallway, in order that you disregard anything from spectators that you might have heard in this case also. You cannot allow anything that you might have heard, if you heard anything, to influence your verdict in this case. You must base your verdict only on the law, only on the evidence that I've given, that has been presented, the law that I've given to you. Do not base your verdict on anything that you might have seen or what you might have heard, because those are not statutory aggravating circumstances. And the fact that Mr. Wilbourn has decided that he no longer wants to be in the courtroom, that's again 100% his decision. You cannot hold that against him and cannot draw any inferences from that also, because that is also not an aggravating statutory circumstance. Does everyone understand that? Ms. Dwyer, you may proceed with your argument.
And I won't belabor the aggravating circumstances, ladies and gentlemen. You know what they are. You've seen them. They're on the board. And if you find one or all three of them exist beyond a reasonable doubt, you weigh them against any mitigating factors. And I would ask you, ladies and gentlemen, is there any mitigation, is there any excuse that you have heard that mitigates against the defendant's hatred of law and order and hatred of everything that represents that? And if you find beyond a reasonable doubt that those aggravating circumstances outweigh any of those possible mitigators beyond a reasonable doubt, then there is only one verdict. And I would submit to you that it's the verdict that truth dictates.